Swayam Prabha. Digital India. Educated India.
So, one of those important cases that we can discuss under Article 19 as well as Article 21 of the Constitution is the landmark judgment of Menaka Gandhi versus Union of India. This case is important because it was a case that was decided post emergency, which was imposed in this country. And this was the time when public administration was slowly changing in terms of the perception and in terms of the kind of application it had in the legal system. You see that post emergency, the judiciary started asserting its role in protecting constitutional rights of citizens. It wanted to curtail executive abuse of power. It wanted to restrict the legislative, arbitrariness, and hence the judiciary came up with some very landmark decisions which laid down the constitutionalism for the coming decades in this country. One such case that changed the dimension of the constitutional structure in this country is the case of Menaka Gandhi versus Union of India. Now, Menaka Gandhi, as it were, was, of course, she was the daughter-in-law of Mrs. Indira Gandhi. She married Sanjay Gandhi, and of course, the mother-in-law and daughter-in-law did not go pretty well. And these were the background to which actions were initiated in the Menaka Gandhi case. Now, if you look at the facts of this case, it is very simple that Mrs. Gandhi, Menaka Gandhi, was asked to surrender her passport under the Passport Act and hand the passport over to the regional passport officer in Delhi. And it was so-called a process of impounding of the passport. And the ground that was given for impounding the passport was as in public interest, without any substantiation of what that public interest actually was. And she was asked to surrender this within 7 days from the receipt of a letter that was issued by the regional passport office. Now, interestingly, Mrs. Gandhi, she challenged this case as being violative of her right to life, but more importantly, also the freedom under Article 19 in terms of the freedom of movement and the freedom of trade, occupation, and business, and the freedom of expression, which are enshrined under Article 19 of the Constitution of India. What is also important is that, when you talk about infringement of the fundamental freedoms that are there as Part 3 of the Constitution, these fundamental freedoms enshrined in 1921 and also Article 14, which we call as the Golden Triangle Rule. 14, 19, and 21, it's called the Golden Triangle Rule. It meant that, can someone challenge any curtailment of his or her personal liberty? Now, personal liberty, friends, is enshrined in Article 21. Article 21 has two components: right to life and personal liberty can only be taken away except unless established by procedure of law. So you will notice that the executive in India prior to emergency was quite powerful. So was the legislature, because the opposition parties were not that very strong. It was almost a single party system in this country, and this led to a kind of a black day in the Indian Constitution by the imposition of emergency in 1975. And it was important that the constitution, democracy, and legal system actually got some kind of a direction about where and how they can proceed. And this case gave the judiciary a very golden opportunity to lay down those kinds of ground rules. Now, Honorable Justice M.H. Beg, the then Chief Justice of the Supreme Court. This bench had Justice V.R. Krishna Iyer, Justice P.N. Bhagwati, and Justice Y.V. Chandrachud, among the other judges who were there in this particular case. And this case was decided by 7 judges in total, and they had to decide the following things. First is that whether fundamental rights are absolute in nature and character or conditional under the Constitution of India. Second, they had to check whether right to travel is protected under Article 21. Is this a fundamental right as well? And what is the connection between 14, 19, and 21? And what is the scope of procedure established by law? And whether Section 10, subclause 3C of the Passport Act 1967 is violative of the fundamental rights. And whether a regional passport officer can impound a passport without adhering to the principles of natural justice. These were some of the challenges that were made in this case. And you will notice that it was argued that the fundamental rights are something that are given to every human being as a natural right. These are rights that you are entitled to enjoy by birth. As a country, you have to ensure this to every citizen of this country. And fundamental rights have to be absolute in nature and character, which means they should not be compromised for any reason or purpose. And the right to travel is a kind of a right that every human being must be entitled to explore your intellectual capacity, to explore different countries and continents, and to be part of any territory of your own choice, ought to be some kind of a right that the Constitution must recognize under Article 21, which is about personal liberty. Personal liberty is of your personal choice, the freedom of movement. So, interestingly, I think any kind of confiscation or revoking a passport, which is the travel document for you to go abroad, ought to be reasonable and lawful. And if it is not, then such an action should be challenged under the Constitution, and a citizen must get a right to bring a petition under Article 32 of the Constitution of India, which gives you a direct right to approach to the apex court or the Supreme Court for the violation of your fundamental rights. I think this case also debated a whole lot of what is PNJ, that is Principles of Natural Justice. That a government which is democratic in character and nature, and a public administration that has to decide about the rights of citizens. Public administration cannot in any way infringe any right or take away any right that is guaranteed and protected by the Constitution unless it follows what we call as procedure established by law. Now, every such procedure that is established by law shall adhere to the principles of natural justice. As we call, when we say principles of natural justice, we also say it is the principle of audi alterum partem. Audi alterum partem means that one must be heard before he is actually punished, or he is condemned, or his rights are being taken. So you cannot seize anyone's passport just on the ground of public interest or public good unless the law gives you the grounds for impounding the same. So I think there was a very interesting argument over here about what is the role of public administration in such matters. And I think in this case, it was very important that the courts did realize that in India, the executive was still having a colonial hangover, and they were not being held accountable as public servants. They were not treating the public fairly, reasonably, and going about exercising their functions in a democratic process. That is probably the reason why the court in this case very clearly held that public administration ought to be reasonable. This is core to public administration and public function. And if public administration is not regulated, restricted, or controlled, then to a larger extent, this kind of an unrestricted power of any authority, which is vague in nature and character, would be abused. And this would result in infringement of the rights of the citizens of India, which the court clearly said will not be permitted under the Constitution. So finally, what the court does in this case is, while restoring the passport of Mrs. Menaka Gandhi, they very clearly say that no one can be deprived of his opinion or voice in the constitution, and hence the freedom of personal liberty is a guaranteed freedom, and every citizen is entitled to enjoy the same under the constitutional principles. And public administration and public policy will be the only determinate factors of deciding whether any kind of an action which is adverse to the citizen's interest can be taken, if so, on grounds that are reasonable in nature and character, and not without following what we call as the principles of natural justice. So this case is an important case to that extent, and to say the least, that what did this case do? It laid down a very important principle of the Constitution of India, that public administration must fall within the test of the Golden Triangle rule. The Golden Triangle rule on the top has Article 21 of the Constitution, which protects the right to life and personal liberty. On the bottom left, it has Article 14, which is equality before law and equal protection of the law. And on the right side, it has Article 19, which enshrines the six essential freedoms that citizens enjoy under the Constitution of India. This prism, or the triangle, is the test of public administration, that any kind of public policy and public administration cannot violate this golden triangle rule. And if it does, then it is subject to a challenge in the court of law, and the courts will intervene to protect the rights of the citizens. Moving forward from Article 19, let us get into the discussion of Article 20 of the Constitution. Friends, Article 20 of the Constitution is one of those very, very important provisions of the Indian democratic legal system, because Article 20 speaks about protection against conviction of offences. So, Article 20, interestingly, is a constitutional protection for convicts who have been sentenced to certain kind of punishment for offences that they have committed against the state. You will notice that the Constitution of India provides safeguards to people who are accused of crimes. This clearly shows the kind of, I must say, moral character that is displayed by the Constitution of India, which means that Part 3 of the fundamental rights of the Constitution are not only there for citizens who are free and who have been on the right side of the law. The Constitution also takes care of accused individuals who have committed crimes, and crimes, as you know, are offences against the state or the society. They are of higher degree and gravity, to the extent that here are individuals who are to be punished by law, yet can have certain constitutional protections. Now, there are three constitutional protections under Article 20 as being safeguard for those who are accused. First is called Article 21, which calls for ex post facto law. Now, ex post facto law, the term ex post facto, friends, is actually a Latin expression. It clearly says that, ex post facto, this means that something that is, an afterthought. You are trying to put something in a retrospective manner, right? Post facto means the action has taken place, but you want to make a law covering that kind of an action. So, ex post facto law, friends, means that a law that attempts to impose penalties or convictions on acts that have already happened or already done. So, when the act happened, the law did not take cognizance of that act. Neither did it treat it as an offense, or neither did it prescribe a punishment for the same. But now the law wants to take cognizance of that kind of an act and treat it as a crime, and also impose punishments and penalties to the same. So, can an ex post facto law, that means a law that gives retrospective effect or gives retrospective treatment, be enforceable in India? Which means, friends, suppose let's take an example of the Dowry Prohibition Act of 1961. Now, This law came into force on 20th May 1961. And after 20th May 1961, if any person is found accepting dowry, he shall be punishable under this act. So 25 1961. This is the date from which the law comes into force. Now, even if I accept dowry on the 19th of May, please note it shall not be an offense, it shall not be a crime. Because the purpose of the law is always prospective, especially the purpose of criminal law. Now, please note, civil laws can have retrospective effect, taxation law can have retrospective effect, but not criminal law, because in crime you are actually taking away the liberty of the individual, you are going to imprison him. It is a serious act of the state, and hence there should be a protection against the taking away of the personal liberty of an individual in a crime. So post facto, law is okay, but ex post facto law is definitely not okay. So you will notice that with the example of Dowry Prohibition Act, you should probably understand that once the law comes into force, that is 20th May 1961, the act of accepting dowry is treated to be an offense, a crime for imposition of penalties and punishments. Anything done before that, definitely under Article 21, you have a protection and you shall not be prosecuted for the same. That is what is there under the protection of Article 20. Now, interestingly, ex post facto laws are of three kinds generally. Okay, this is the broad framework if you want to know. First is a law which declared some act or omission as an offense for the first time, right? And after commission or completion of the act, the law treats it as an offense. This is one part of it, because suddenly, we did not know that such acts and omissions can take place. So once one act is done, immediately the law comes into place and makes that kind of an act or omission crime. So this is one way in which ex post facto law is attempted to be made. Second, a law which enhances the punishment and the penalty. So please note, in ex post facto law, the offense could have already been taken into cognizance. But now what you do is you bring in a law and you enhance the punishment and the penalty. So when I committed the act, maybe the punishment was 3 months. Now you bring in a law that increases that punishment and penalty. And this happens from time to time, that the parliament or the legislature thinks that the current punishment or the penalty is not amounting to enough deterrence. And hence the enhancement of punishment or penalty is very much required and necessary under the constitution and also under the criminal procedure code. So this happens from time to time. But the fact is that the act has already been done by me. It was an offense, no doubt, but attracting only 3 months of punishment. Now, should I be entitled to just that 3 months of punishment, or to the enhanced punishment that has been brought about by a new law, which tends to then be made applicable prospectively generally, but should not be made retrospectively applicable? So that is also one element of ex post facto law that can actually come into place, where the punishments and the penalties are enhanced subsequent to the commission of that kind of an act or an offense. The third kind of ex post facto law is a law which prescribes a new and a different procedure for prosecution of offense. So this may be in terms of tilting the burden of proof on the accused instead of assuming that he is guilty. Assuming that he is innocent till proved guilty. You come up with a new procedure of trying such kind of offense. For example, you can put it in the fast track court. The fast track court is a special court. It's not necessarily bringing about a new procedure, but in that you not only bring the fast track court, but bring about a new procedure for speedy trial, summary trial. You're not giving enough time for the accused and his counsels or the defense counsels to actually put forward their arguments and cases or cross-examine individuals, or some kind of new procedure that is brought in to finish cases early. Those kinds of ex post facto procedural laws can also be something that can be brought about under Article 21 and can be tested under Article 21. Now, among these three, please note the first two attract Article 21, 20 subclause 1, and they are prohibited under Article 20. Which are the first two? First, in which you actually declare some act or omission as an offense after the completion of the same. right? So this is like once an act has been done, now you treat it as an offense. This is prohibited under 20 subclause 1. Second, you enhance the punishment and the penalty for acts already being done. These two things, please note, the Indian Constitution does not permit, and the doctrine of ex post facto law will be granted to an accused, and he'll be protected against these two actions of the state if they are attempted to be done by the state. The third aspect, which is about new procedures. See, new procedures are not affecting your substantive right, and hence, any kind of a new or a different procedure for prosecution of offence can have retrospective effect. This is to ensure speedy trial, to have quick disposal of cases. This is to actually try and finish the trial in a time bound manner. Maybe we have a case management rule where we say that, look, this is the time for how many adjournments can be sought, this is the time for replies, this is the time for cross examination, so on and so forth. So those kinds of procedures are definitely that you can bring, and you can apply it retrospectively. I don't think anyone can challenge it as being violative of Article 20. So Article 21 simply says something like this. Please note it down. It says, no person shall be convicted of an offence except for the violation of a law in force at the time of the commission of the act, charged as an offence, and nor be subject to a penalty greater than which might have been inflicted under the law in force at the time of the commission of the offence. This is how probably one reads Article 21, which is about ex post facto law. Now, you must notice that, generally criminal law tends to have quite strict punishment. And I think the accused must get the benefit of any such law that exists, and he must not be subject to any kind of mistreatment or enhanced punishment, as the case may be from time to time. Now, the second part is the law on double jeopardy. Now, you will notice that double jeopardy is also a kind of a protection that is being given to an accused. Now, the law on double jeopardy clearly, speaks about what is the right to an accused in a criminal case or a criminal trial. It is called the doctrine of double jeopardy, and it says that no one shall be punished for the same offense twice. That is what the doctrine says. So, usually, if you look at double jeopardy, you can trace its origin to the American jurisprudence, which actually said that no person shall be prosecuted and punished twice for the same offense in any subsequent proceedings. So, Article 20, subclause 2 reads like this. Please note it down. No one could be convicted and punished more than once for the same offense involving the same set of facts, and there is a guarantee against multiple convictions, which is the doctrine of double jeopardy. So, in the case of Venkat Raman versus Union of India, the Supreme Court of India established this doctrine, and it dealt with this doctrine. However, it said that this applies to only judicial punishments, not quasi-judicial or departmental punishments. So, departmental punishments are brought under a purview of what we call as parallel proceedings. And your departmental inquiry could be different, your judicial inquiry can be entirely different. But the protection of double jeopardy is only in case of judicial proceedings, right? So, vis-a-vis the judiciary, you cannot be prosecuted twice by a judicial authority. So, usually you should be clubbing all judicial processes, and you should be getting a punishment or a penalty only once for the same set of facts. This is what is the doctrine of double jeopardy. So, usually what happens is, if suppose you have been caught at the customs authority, or see, the customs authority are at the seaport, they are at the airport, and in violation of the rules of custom, you have actually brought certain gold from abroad, and you were found in possession of that kind of a gold which you are not supposed to get or import into India. Now, please note, the customs authority will confiscate this kind of a gold, and they will probably take about a proceeding before a criminal court. Now, once it is being taken in a criminal court, please note, you shall be prosecuted under the criminal law, and you cannot be prosecuted again for the same offense by the customs authority in the customs court. So this is something that is clearly prohibited unless, in a nutshell, you will notice that the departmental inquiry is quasi-judicial and the criminal proceeding is considered to be judicial. So, for the same set of facts, you may have a civil kind of an action, you can have a criminal kind of an action, and you can have a departmental kind of action. That will not be considered as double jeopardy. But a criminal court punishing you twice for the same offense is double jeopardy, and you have a protection against the same under the Indian law. So another provision which helps you understand double jeopardy under Article 20 subclause 2 is Section 301 of the CRPC, Criminal Procedure Code. Section 300 subclause 1 of the Criminal Procedure Code says that someone who has been convicted or prosecuted by any competent court for some offense will not be liable to be prosecuted again till the previous conviction remains in force. So once you are convicted for the same set of facts and offenses, you cannot be tried again in a court of law. So you have a protection against conviction for the second time for the same offense for the same set of facts. This is what is the doctrine of double jeopardy. So, of course, this should be good enough in understanding what double jeopardy is. Let us move on to understanding the prohibition against self-incrimination that is there under Article 20, subclause 3. Now, the protection that is given against self-incrimination means that no one shall be forced to utter or provide any such information or evidence, orally or by any documentary proof, which could be used against that individual. So I have a protection. I need not utter or confess to my crime. I need not provide any oral or documentary evidence that may lead to my own conviction. So protection against self-incrimination. That means self-incrimination means trying to incriminate yourself before a court of law or before a police or investigating agency, and you are leading them to your own kind of a crime. So this is a protection that you have. And here you will notice that the self-incrimination rule or protection is available to you as a witness, both in terms of oral and documentary evidences. And you need not help the authorities in finding your own guilt or your own fault. It is their job. So the burden is on them to prove the crime, and you can actually not facilitate such kind of investigation or collection of evidence. But please note, if you decide to give that evidence voluntarily or that information voluntarily, then you are not necessarily covered under Article 23. So if you wish to give that information and evidence, you have the freedom to do that. However, if you wish not to do it, then it is not to be treated as a crime. That is what is very clearly stated in Article 23. So let's take something like this, right? So suppose one is being tried for murder, and the police is investigating the offense of murder, and they come to me and ask whether this man has committed murder. Were you there? Did you see? And so on and so forth. So in those cases, you have the right to remain silent. You don't have the right to necessarily disclose, what has happened, unless there are certain cases where, please note, the third party owes a duty to cooperate and inform the police. But if I'm the accused in that case, I need not help the police. I need not give information and evidence that may lead to my own guilt in that case. Whereas every other citizen has a duty bound to help the police and the legal system and the authorities in detecting crime, and cooperating with them is a duty that is enshrined in the legal system as well. So, yeah, there are some very interesting cases on the same, and you will notice that the Fifth Amendment to the Constitution of the United States of America also has a very similar provision that protects accused against self-incrimination. And similarly, in India, we have incorporated a similar protection to the accused as well, so that they can actually remain silent and they need not actually facilitate their own finding of guilt, as the case may be.